Anjali, should we start?
Sure, sir.
All right. So
Yes,
now
sir.
we have done with the one major part with regard to the individual insolvency, and as we have understood that failure of individual insolvency or failure of repayment plan or no approval of repayment plan does not give a compulsory commencement of bankruptcy. It is only giving a right to the debtor or to the creditor to start bankruptcy. Now, what is bankruptcy? What is the meaning of bankruptcy? So, bankruptcy is defined in section 79(3) of IB code, where the bankrupt means a debtor who has been adjudged as bankrupt by the bankruptcy order under section 126. That means the condition is there should be order of bankruptcy. I cannot call everybody and anybody as a bankrupt without having an order of bankruptcy. That is a precondition. Each of the partner of a firm where the bankruptcy order under section 126 has been made against the firm. So if it is against firm, all the partners of the firm will be considered as bankrupt. Any person adjudged as undischarged insolvent. So there should also be order with regard to undischarged insolvent. Then only you will be considered as bankrupt. Otherwise, you are not considered as bankrupt. In other countries, the similar definitions are provided. Application for bankruptcy order. Insolvency process is a precondition. Why insolvency process is a precondition? It is again a proactive law. It says that any person who is an entrepreneur, who is a businessman, who has taken the risk to initiate the business process, he should not be declared bankrupt straight away. He should be given one opportunity to do a completion of his resolution, because resolution is always considered to be more beneficial for all the stakeholders to retain the value of business. So like in CIRP, without CIRP process, liquidation cannot take place. Likewise, here also bankruptcy cannot be commenced unless and until you have explored the option of insolvency. Direct bankruptcy cannot be filed. So it is not like that today if the insolvency process has been initiated and immediately I'll be declared as bankrupt. No. You can always settle it out. You can plan for repayment plan. It can be filed either by debtor or by creditor. Joint application can also be filed. Within 3 months of the order, which is passed by the adjudicating authority under section 104, 115, 118, the three situations where the rejection of application is there, or repayment plan is rejected, or there is a premature termination of repayment plan. Application may propose the insolvency professional to act as a bankruptcy trustee. Application, of course, cannot be withdrawn without the leave of the adjudicating authority. Interim moratorium will commence as soon as the application is filed. Application for bankruptcy order. Creditor is entitled to file an application. Application for IRP is rejected by the adjudicating authority under section 104. On order of adjudicating authority, both can file. In case of rejection of repayment plan, and both can file on the premature abortion of repayment plan. So this is the whole process of bankruptcy. Application is filed, nomination of bankruptcy trustee within 14 days, bankruptcy order by adjudicating authority, bankrupt to submit the statement of financial position to bankruptcy trustee if the application was filed by creditor within 7 days, notice or the public notice by the adjudicating authority inviting the claims from the creditors. Creditor will register their claim within 7 days. Bankruptcy trustee will prepare the list of creditor within 14 days. Within 21 days, he'll summon a meeting of creditor. Completion of administration and distribution of estate. The report of administration will be submitted by the trustee. Within 7 days, if there is a meeting of creditor required, then approval of trustee report by the creditors committee and determination whether the bankruptcy trustee shall be released or not. Modification or recall of the bankruptcy order. Condition: it appears to the adjudicating authority that there exists an error apparent on the face of such order. Both bankruptcy debt and the expenses of the bankruptcy after making the bankruptcy order either have been paid for or secured to the satisfaction of the adjudicating authority. In this condition, it can be passed, adjudicating authority can pass. An effect of modification or recall, that is sale payment by bankruptcy trustee, remain valid. Property of the bankrupt shall vest in the such person as the adjudicating authority may appoint or may revert to the bankrupt on the terms as may be directed by the adjudicating authority. Order is binding on all creditors so far it relates to the bankruptcy debt. Now, what is the effect of bankruptcy order? Section 128. Bankruptcy estate will vest in the bankruptcy trustee. Moratorium will commence and it will immune from any action by creditor with respect to property of the bankrupt or with regard to any legal proceeding without permission of the adjudicating authority. Division of estate will be, that is the distribution of estate as per section 178 will be carried out. Moratorium, there are certain things which are barred, there are certain things which are not barred. What is barred? Any action against the property is barred. Filing of any legal suit or proceeding is barred except with the permission of adjudicating authority. And bar is only when there is a financial implication. Not barred. What is not barred is enforcement action by the secured creditor. Punitive action by for misconduct, contempt, or recovery of excluded debt. What we learned, like your alimony, the maintenance, the education loan, right? So, or any tortious liability or any fine penalty. So those all can continue. You cannot take shelter that now bankruptcy proceedings are going on and I am immune. No. Criminal proceedings, which are Even in section 14 also, we have learned that these are the proceedings which are not barred. So in the case of the individual insolvency as well. Statement of financial position is required to be submitted to the bankruptcy trustee by the debtor in all creditor filed application. अगर creditor application file करता है तो debtor को within 7 days financial position का statement submit करना है. Format is prescribed by the IBBI. Penal provisions are there in section 186. If there is any false representation, or if there is any willful omission or concealment, or while providing any information during the bankruptcy process, then these actions can be taken. The statement of financial position is also a way to track the past financial history of the debtor, particularly to find out the vulnerable transaction. Can creditor seek copy of the statement of financial position? UK law specifically empower. In India, the law is not so very explicit, so it is difficult to understand as to what will be the position if a creditor asks the position of a statement of financial position from the bankruptcy trustee. Disqualification of bankrupt. Now, this is very interesting. Somebody should understand as to what is the consequence in India. So far, because it is a very small time that has passed from the commencement of insolvency and bankruptcy law. And prior to that also, there is a lot of taboo issue that is associated with being declared as bankrupt. But let us understand honestly as to what is the consequence if I am declared as a bankrupt. Under IBC, I cannot be appointed as a trustee. All right. I cannot be appointed as a representative of any trust estate or settlement. I cannot be appointed as a public servant. I cannot be elected to the public office where appointment of such office is by election. I cannot be elected or voted as a member of any local authority. I cannot act as an insolvency professional also. So these are some 5 disqualification under IB code. Under Companies Act, if you recall section 164, 1B, 1C, I am restricted from being appointed as a director. I am restricted from being appointed as a managing director, manager under section 196. I cannot be appointed as a member of NCLT, NCLAT. I cannot become a registered valuer. I cannot be empaneled as a mediator, conciliator. Under other laws, I cannot become partner under LLP law. I cannot become partner of even partnership firm law. I cannot become a member of IRDAI. I cannot become even a company secretary, chartered accountant, cost accountant. I cannot become a notary under the Notaries Act. I cannot become a member of any forum, commission under the Consumer Protection Act. I cannot become a contractor under the Contract Labor Regulation and Abolition Act. I cannot become a member of Board of Reserve Bank of India or other bank. I cannot hold any constitutional position under the Constitution of India. There are similar other kind of disqualification under various other laws. But this is just to give you a glimpse of what all consequence can be. So this is a broad framework of restriction which are imposed on the bankrupt. He cannot be a member of a professional body, cannot act as a director promoter. He cannot travel overseas without the permission of adjudicating authority. That restriction was not there on the person who is undergoing insolvency. But once you are declared bankrupt, you cannot travel abroad without the permission of adjudicating authority. You cannot create any charge on his own or further. You cannot take any further debt without the approval of bankruptcy trustee. You must inform about the business partner to the business partner regarding the ongoing bankruptcy. You have a venture where you are also a partner. So you must inform. You must inform the party before entering into any transaction of rupees 1 lakh or more. You cannot maintain legal proceeding with respect to the bankruptcy debts. So these are the restrictions on the bankruptcy. What is the bankruptcy state? What will be included? What will not be included? So all property of the debtor or the bankrupt at the bankruptcy commencement date automatically vest in the bankruptcy state, bankruptcy trustee. All the property which by virtue of any provision of the code is comprised in the state, such as a preferential transfer, undervalued transaction, if that is also coming back to a debtor, that will also be part of the state. The capacity to exercise and to initiate proceeding for exercising all such powers in and over, like you have a receivable, then again in respect of those receivables also you get that power. But what it does not exclude, what it does not include is also important. As we learned, excluded assets, that is your unencumbered personal asset which is required for your vocation, profession, employment, furniture, fixture, jewelry, dwelling house, pension fund, right? All these assets are your personal assets and they cannot be part of your bankruptcy state. These will retain, this will be remain to you, which are required for your survival. The property held by bankrupt on trust of any other person. I am not owner of those, but somebody has given a property to me in trust that, okay, you use for the time being. Or I will take it 1 month after. And bankruptcy trustee came that on bankruptcy commencement date, I found these assets at your household. They cannot be taken. All the sum due to any workman or employee from the provident fund, pension fund, gratuity fund, this is already part of the excluded asset, but for sake of clarity, they have provided, because provident fund was not included, but it is included here. Such assets, again the residual provision. Residual provision is there in the assets definition also, here also. Tomorrow, it can be excluded. So these are all the same detail what we have already learned. Now, what are the functions and duties towards the estate? Section 149, 150 deals with this. And functions of trustee is to investigate into the affairs of bankrupt, realize whatever is there in the estate, and distribute. Investigate, realize, distribute. Duty is to give to the bankruptcy trustee the information of his affair. This is a duty of bankrupt. Bankrupt is obliged to provide all the information of the affairs to the bankruptcy trustee. He is obliged to attend the bankruptcy trustee at all times as may be required. He is required to give notice to the bankruptcy trustee of any significant event which have occurred after the bankruptcy commencement date. What is the general power of bankruptcy trustee? He can sell any part of estate. He can give receivings. He can prove, rank, claim, draw any dividend in respect of debt due to the bankrupt as are comprised in the estate. He can exercise right of redemption with respect to any of the property held in hypothecation. He can deal with any of the property in the bankruptcy state. Now, as we discussed earlier, Section 153 puts a restriction on bankruptcy trustee as to these actions. If you are going to take, you can take only with the permission of creditor. If you want to carry the business of bankrupt, today I was a garage owner and you as a bankruptcy trustee got vested with this garage also, provided it is not excluded. Then if you want to carry the business, which is, let's say it's a profitable venture and the bankruptcy process will take a year time, you don't want to lose the revenue for a year, or you want to continue the business so that it can be sold for a value for money proposition, then you need to have a permission of creditor. Second, if you want to initiate or defend any legal proceeding against the debtor, you need the permission of creditor. If you want to accept a sale consideration at a future time, that is, you want to give a credit, permission of creditor is required. If you want to mortgage or sell any property for raising money for payment of debt of bankrupt, there is an obligation also. But you want to pay that obligation by creating a mortgage or sale, permission required. Arbitration or compromise with respect to subsisting debt or any compromise or arrangement will be requiring the approval. If you want to make any payment or incur any liabilities with a view to obtain for the benefit of creditor rights which are attached to the assets, then also the permission is required. And last, if you want to appoint the bankrupt to supervise the management of estate, carry on the business, or assist the trustee, even in those cases also, you are required to take a specific permission from the creditor. Otherwise, the bankruptcy trustee is empowered to conduct all the proceedings as per the provisions of the IB code. Now, what is the role of creditor under the bankruptcy? The first meeting of creditor within 21 days, that is one obligation. Primary business of the first meeting is to constitute the committee of creditor. The committee is constituted by the trustee. Composition of committee is not laid down in the code or in the regulation. Voting share, though not mentioned, but it is understood that it is always in proportion to the debt. Voting percentage for the general meeting is not given in the IB code or in regulation. 134(3) provides the passing of resolution. Logically, it should be simple majority, except where it is specifically mentioned. So trustee is obligated to intimate to the adjudicating authority within 3 days of constitution. Bankruptcy trustee is required to give a notice to every creditor within 14 days. Interest on debt provable as a part of debt till the bankruptcy commencement date. It is mandatory to call a meeting of creditor under section 133, associates are not entitled to vote. Committee of creditor is to be established. Creditor approval is mandatory for certain action, as we have learned. Voting share, where whole amount payable by CD, where the resolution plan for CD is not yet approved. That means if a resolution plan for the CD is pending approval, whole amount will be considered for the purpose of voting. Where CD is in liquidation and creditor has relinquished the security interest, amount claimed less what is proposed in the distribution, what he is likely to get. Where CD is neither in resolution nor in liquidation, amount due from CD as may be demanded by the guarantor. Where the resolution plan of the CD has been approved, only the amount of haircut. So this is the mechanism by which the vote share will be decided in various situations where the resolution plan is approved, is yet to be approved, where the part has been admitted, part has been paid, relinquishment, non-relinquishment, all these situations are provided. Regulation 30, with regard to the valuation of assets. We know valuation is not mandatory as against the process of CIRP or liquidation. When valuation is required, when bankruptcy trustee is of opinion that the valuation is necessary, without that we cannot. So we as a professional, we would always like to proceed with the base figure as to what is the value of the asset, so that you can tomorrow defend your actions also. Or when the committee decides that no, valuation is necessary, in those cases also. What is to be valued? Assets which are forming part of the estate and assets which does not form part of the estate. Everything has to be valued. Mode of sale, auction. By default, all the assets will ordinarily be sold by auction, except in case of condition for private sale. So this provision is very akin to what the liquidation provides. Private sale is allowed if the asset is perishable in nature. If value of asset is likely to deteriorate, the selling price of asset is higher than the reserve price of a failed auction. In that case also, private sale can be allowed. Here again, there is a restriction on purchase of assets by certain people. Bankruptcy trustee, partner, director of his IPE entity, professional appointed by bankruptcy trustee, any creditor, company where bankrupt is a promoter director, company where creditor is a promoter, or associate of the bankrupt. These are all prohibited category. A quick look on the waterfall as per section 178. So this is similar to what is there in section 53, except one difference. You will find out that there is no distinction between financial creditor and operational creditor. Insolvency resolution cost or bankruptcy cost, workman dues 24 months, secured creditor, wages and employees dues 12 months, government dues, and then other debts. And interest comes at the last. And trustee has to make an application to adjudicating authority within 3 days of submission of the final report for an order for deposit of unclaimed dividend, undistributed asset, or any balance which remains payable to the creditor. And similarly, trustee will be required to submit a statement including name, address, amount, and the value of the assets. So this is very similar to, and same option lies here also with regard to the secured creditor. Relinquishment or no relinquishment. It is related to your voting right also. If there is no relinquishment of security interest, he would have first filed a claim separately to the secured and unsecured portion. Trustee has the right to put an alternative buyer. These are the rights. If he relinquishes security interest, claim against the bankruptcy estate and get a top priority under section 178. Secured creditor is a lender that provides a collateralized debt. Secured creditor shall have a right of a secured creditor only up to the amount of security not relinquished. A secured creditor is taken as secured only to the extent of value of security interest. Bankruptcy order will not affect the right of any secured creditor to realize or otherwise deal with his security interest in the same manner as he would have been entitled if the bankruptcy order was not passed. So this is the option available to the secured creditor in respect of this. Onerous property is also provided, that there could be situation that debtor is having a onerous property. Section 160 deals with onerous property. Essentially means any unprofitable contract and any property which comprise in the state of bankrupt, which is unsellable or not readily sellable, or is such that it may give rise to a claim. Who is a person interested in bank onerous property? Any person who claims an interest in the disclaimed property. Any person who is under a liability in respect of the onerous property. Where the disclaimed property is a dwelling house. Any person who is in occupation or is entitled to occupy the dwelling house on the date of filing of the application. So bankruptcy trustee may give a notice to the bankrupt or to any person who is interested in the onerous property, disclaim any onerous property which forms part of the estate of the bankrupt. As far as the avoidance transactions are concerned, a provision which is similar to section 43, 45, 50, 60 is also existing here. An undervalued transaction between the bankrupt and any person. Undervalued we all understand, which is there. 2-year look back period is all across. Preferential transaction where the preference is given. An extortionate credit transaction may also exist, and basis the same proceedings can be initiated here also. Now 138 is very important and interesting to understand. What is the discharge order? Section 138 says that on expiry of 1 year from the bankruptcy commencement date or within 7 days of the approval of committee of creditor of completion of administration of estate, which is of course prior, before 1 year also, you can file an application for discharge. So discharge will be ordered. What will happen on discharge? The bankrupt is released from all bankruptcy debt. Excluded debt will remain excluded. Bankrupt will remain liable for the excluded debt. But you will be discharged from. So whatever restrictions we have learned, that the bankrupt cannot become a public servant, he cannot become company secretary, he cannot become chartered accountant, he cannot become cost accountant, he cannot become a member of any tribunal, and so on. He cannot become a director, managing director. All these restrictions are only till the period he is not declared discharged. And what is the discharge period? Discharge is 1 year. That is the outer limit. If I go with the law, what will tomorrow adjudicating authority will do? I am not commenting on the same, but legally law says that 1 year is the outer timeline during which a person can remain bankrupt as per IB code, in which the entire proceeding has to be completed. And during that period only, the restrictions are applicable. And once the discharge order is passed, I can become director, I can become managing director, I can do all the business as I was capable of doing otherwise. But discharge order does not affect the right of a secured creditor to enforce the security interest. Bankrupt is not released in respect of debt incurred by means of fraud. So fraud vitiates everything. If there is a fraud, then that's a different matter. Bankrupt is not released from the excluded debt. Rest everything, he is released from all kind of liabilities. So that's it from my side as far as the insolvency and bankruptcy of an individual is concerned. We have learned what the evolution of insolvency and bankruptcy code was, some changes, what are the law has made, how the insolvency impact to different people, behavioral change, safeguard, liquidation and understanding the waterfall, and doing a comparative analysis of CIRP process versus insolvency process individual, insolvency versus bankruptcy, bankruptcy versus liquidation, bankruptcy, discharge, and all. I am done with, and I'll request the participants to unmute and we can have some, maybe there is still 20 minutes time. So we can make deliberations on various aspects of whatever discussion we had in 2.5 hours of time. Can we take few questions, or if anybody has got any experience with regard to any of the peculiarities with what one has gone through? The questions could be when guarantee contract shall become enforceable, the subrogation principles could be one, limitation I think is one area where the deliberations are required. What is the starting point of limitation? If limitation period will begin from the date of breach, or it will begin from the date when sureties are crystallized, of limitation will begin actual date of demand of payment, or limitation will begin from the date of recall notice, and what is to be excluded from the limitation period. I think that is one jacket where the lot of questions should be there or deliberation should be made. Once we have understood the basic nuances of individual insolvency and bankruptcy, is there any impact of moratorium in CIRP on limitation? Limitation means limitation law with regard to the individual insolvency. Limitation period in case of security, in case of part payment, acknowledgement of debt, Now, one question which has been deliberated, I think, in many of the forums and before the adjudicating authority, who shall be adjudicating authority in case where no corporate insolvency process or the liquidation proceeding of a corporate debtor is pending before any NCLT? Can NCLT take cognizance of the same and take up the insolvency resolution process? And likewise, I think these are few of the thoughts, few of the questions which are in my mind. Maybe if anyone has dealt with any of the provisions of individual insolvency, maybe you can throw some light and the forum can benefit from your experience as well. Anjali, over to you. You can coordinate for the questions if there are any from
Sir,
the...
I have a doubt on individual insolvency, sir.
Yeah, please.
Although it doesn't have a practical application right now because the provisions are not yet notified, I wanted to know the rationale behind the fresh start process. And if we see the threshold limit which is prescribed, so it is very less right now, very low limit, 35,000 or so sort of. So what is the rationale behind, what is the idea and object behind that fresh start process provision? Because I remember one year back, finance minister had told that we are thinking of notifying the fresh start process soon. Maybe, I don't know when it will be notified, but what's the object of that particular provision?
See, the objective of fresh start process, I agree, the limits, if you see the entire insolvency and bankruptcy code, all these limits, whether it is in respect of fresh start process, whether it is in respect of excluded asset, whether the dwelling unit, all these assets have a historical background. And whatever provincial insolvency laws were in existence, somewhere we have borrowed the principles from there. So objective of individual insolvency, whether it is a standalone fresh start process or the individual insolvency, or for that matter, bankruptcy, all are beneficial. This is a beneficial legislation. In India, still I am saying it is a taboo that we all are governed with, that we consider that if somebody is bankrupt, that I'll not like to deal with. Maybe the extent is that if somebody is declared bankrupt, he may find a difficulty in finding out a life partner also. Whereas in the countries outside India, the persons have reached to the highest height of the, you can say, human race. They have become the president and prime minister of that very state. Those kind of laws are in existence, but we are still in a very nascent stage. If you see the overall mechanism by which the insolvency law is especially focusing on the individual insolvency, fresh start, and bankruptcy, all three are motivated that once default does not mean that it is coming an end to the life of a person. Even if so, the objective is to create a distinction between the fraud and the genuine failure of the business. It is to promote the entrepreneurship. It is to encourage the people to take the risk. If I don't get the fresh start opportunity, if I don't get the opportunity to come back and stand again on my own feet, why at all I will like to take the business risk? No businessman will like to take the business risk unless and until he gets the opportunity of these kinds. If I get the opportunity of this kind, the example that I was giving, that ABC Limited taken the loan of 100 crore, where a State Bank has lent the money. A State Bank could realize only 25 crore. 75 crore is the liability of a Mr. A by way of a personal guarantee. Ever in his life, he'll not be able to pay off. That means once I have done the business and I have failed, that means that is end of my life. I should go and do my suicide. No. Law says you have to follow the process. Either you can opt for fresh start process, provided you are coming within the framework and the limit. I agree that limits are very less, but if you qualify, all right. If you don't qualify, you have still the other options. That options are like individual insolvency. You can go, you can then after failing that also, you have a bankruptcy process. So I have learned at max in bankruptcy also what is all happening. Whatever barrings are there, those barrings are only for a year, nothing more. I'll still be able to survive. I will do my homework. I will do my business. I will do my other activities. And after a year time, I'll again bounce back with my business ideas, with my business activities again. So over a period of time, yes, on the practical front, whether the credit rating agencies are going to allow the credit facility to a bankrupt is a question mark in India. Whether a person who has been declared as a bankrupt, whether somebody would like to take him as an independent director or not, because these are all issues which are societal, which are going to crop up, because we have not seen, to best of my understanding, not a single bankruptcy case has yet been initiated in India under the IB code 2016. It's going to be fourth year after individual insolvency is notified. Maybe it is limited to PG to CD cases, but even in those cases also not a single case has been initiated so far. Insolvency cases are there, their failures are there. After failure, again, bankruptcy has not been initiated. Why? Because many reasons. Because in case of a corporate, which is a more structured form of a business where the lot of information is in the public domain, that is Ministry of Corporate Affairs, income tax, this, that. The individual is completely unstructured. You can't expect the information to be in the public domain. And even in the history of last 50, 60, 70 years of our independence, after independence, you can just count the number of cases where the decree implementation has been successful. Means the decree order, this kind of law was there in earlier also, na? Why it is not something new. Maybe individual insolvency is a new thing, but the enforcement of debt proceedings were already there, right? The court was passing the order, and the district administration was going for the decree process, and the realization was made. But how many cases actually the realization has actually been successful? Perhaps due to that reason, still the creditors have taken a time. I think it will take still more time when the confidence will again be there that no, this process perhaps can lead to generation of some more realization of wealth, and giving the opportunity also to the bankrupt, to the person who is at a verge of dying because of the failure of the business. It can give a life to the business again, because he is filled with the idea. He is having idea as to what should not be done so that the business should not fail. But I think it is going to take more time. Your point is absolutely valid that limits are low, but as the individual insolvency complete process is going to be notified for all, maybe government will also reconsider all these limits also. But as of now, I think we have to live with these limits only.
Thank you, sir.
Yeah, all right. Yeah, anything more on or any maybe many of I can see the name of people who have been acting as a resolution professional for many of the individual insolvency matters also. So maybe for benefit of forum, I'll request them to share some of their experiences as well. Maybe we'll all benefit. Anjali, can you just check or we can close the proceedings?
All the participants, whether anyone want to ask the questions from sir? Sir, I think we should conclude the session.
All right. Thank you, Anjali, and thank you, ICSI, and thanks to all the participants also for.
Thank you, sir.
Yeah, thank you.
Thank you so much, sir. Such a valuable and informative session.
Thank you. Thanks to all. Thank you.